federal judge just dealt a massive blow to a 92-year-old gun registry. The Department of Justice sat quietly while the appeal window ran out, and within hours, gun owners were walking out of a Texas gun store with suppressors they did not fingerprint, photograph, or register. But here is the part I cannot stop thinking about, and the part that not even the lawyers I follow were fully ready for. Reports out of the last 72 hours suggest the ATF has shifted into a posture that gun law insiders are calling a counterattack. It is not with raids, and it is not with seizures. It is with paperwork and with silence. And if you do not understand what that means for you, you could walk into a gun store this week and accidentally break a federal rule you did not know still existed. If you own a suppressor, an SBR, a short-barreled shotgun, or you are even thinking about buying one in the next 60 days, you need to hear every word of this before you spend $1 or sign a single form. Quick question before we keep going. Are you actually subscribed to this channel? Because what I am about to break down could literally keep you out of a federal courtroom. I am not being dramatic. Hit that subscribe button and ring that bell right now. Right now. Mean it. Click it. I will even wait. Good. Now let us get into this. Let us rewind the tape just a little bit so the rest of this video actually makes sense. On July 4th, 2025, President Trump signed a sweeping piece of legislation called the One Big Beautiful Bill. It was a giant reconciliation package stuffed with tax cuts, spending changes, energy policy, and about 1,000 things nobody on cable news had time to read. Buried deep inside that bill, in one short paragraph, was something gun owners had been dreaming about for almost a century. Effective January 1st, 2026. The $200 tax stamp under the National Firearms Act was eliminated. Gone. $0 for suppressors. For short-barreled rifles, often called SBRs. For short-barreled shotguns, often called SBSs. For any other weapons, the strange little category most people have never heard of. For 91 years, since 1934, if you wanted to own a silencer for your hunting rifle, you had to pay $200 to Uncle Sam, mail in fingerprint cards, mail in passport photos, get your local chief law enforcement officer to sign off on the paperwork, fill out a Form 4, then wait somewhere between 3 months and a full year while the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, processed your application. Congress wiped that $200 tax out. With one sentence in one bill, that alone made national news, that alone made history, and most people in the firearms community thought that was the end of the saga. Most people, as it turns out, were wrong. Now here is the plot twist that changed everything. On August 5, 2026, a federal judge by the name of Wesley Hendrix, sitting in the United States District Court for the Northern District of Texas, issued a ruling in a case called Silencer Shop Foundation versus ATF that made the previous tax victory look small. The judge did not just say the $200 tax was unconstitutional. He said the entire registration scheme sitting underneath it was unconstitutional as applied to suppressors, short-barreled rifles, and short-barreled shotguns. The fingerprinting, the photographs, the Clio sign-off, the Form 4, the Form 1, the waiting period, the entire bureaucratic stack. The judge ruled, in plain English, that the federal government cannot constitutionally require ordinary gun owners to register, fingerprint, photograph, and pay a tax to possess these specific items under the legal theory the government had been using since the New Deal era. That is not a tweak at the margins. That is a demolition of the entire framework. And here is the second twist, because after the ruling came down, the Department of Justice had 7 full days to file an appeal and ask a higher court to pause the decision while the case played out. Attorney General's staff, ATF leadership, the White House, all of them went quiet. Midnight Central Time on August 13, 2026 came and went. The clock ran out. The Department of Justice did not appeal. Let that sink in. The federal government had a full 7-day window to slam the brakes on this ruling, and it simply chose not to try, if this is making sense to you. My next video is going to walk through the exact 6 questions to ask your dealer before you hand over cash for a suppressor. Under this brand new framework, subscribe right now so you do not miss it. So at 12:01 a.m. Central Time on August 13, 2026, the injunction became real and legally enforceable. Then, roughly 60 minutes later, 2 men, Brandon Herrera and Wes Vertel, both members of Gun Owners of America, walked into a silencer shop storefront in Leander, Texas. They filled out a standard ATF Form 4473, the same for many regular gun buyer signs for any regular handgun or rifle purchase. Their dealer ran a standard NIC's background check, the same instant check that happens every single day at gun stores all over America. They signed on the dotted line. They walked out with their suppressors. No Form 4, no fingerprint cards, no passport photos, no $200 Tax, those, depending on which set of reporting you trust, were either the first or among the very first unregistered silencers to be legally transferred to a private citizen in the United States since the National Firearms Act was passed in 1934, 92 years. That is how long Second Amendment advocates had been fighting for that moment, and it happened at 1 in the morning in a small Texas town with 2 guys, a camera crew, and a stack of paperwork that took 20 minutes instead of 20 weeks. Plaintiffs cried on live stream. I am not exaggerating when I say grown men teared up because of a form they did not have to fill out. Now I want to slow down and walk you through exactly what this court order covers and, just as importantly, what it does not cover, because this is where I see a giant wave of misinformation already spreading online, and the last thing I want is for you to act on bad information and end up explaining yourself to a federal agent. The injunction does not apply to every gun owner in America. It applies to a specific named list of parties that includes customers of Silencer Shop, members of Gun Owners of America, often called GOA, members of the Second Amendment Foundation, often abbreviated SAF, and members of the Firearms Policy Coalition, often called FPC. If you are a member in good standing of one of those 4 groups, or if you are buying your suppressor through Silencer Shop, then you are currently within the scope of the court order, and the registration requirements do not apply to you if you are not a member of one of those 4 groups and you are not buying through Silencer Shop. Then functionally nothing has changed for you yet. The form for path, fingerprint cards, passport photos, Clio sign-off, and the long wait, that is still the law you live under. Let me explain that with a quick hypothetical example so it really, actually sticks. Imagine a guy named Mike. Mike lives in Ohio. Mike is not a GOA member. Mike is not an SAF member. Mike did not even know Silencer Shop existed until he clicked on this video. Mike wants a suppressor for his AR-15 so he can stop blowing out his eardrums at the indoor range. Mike walks into his local gun store and asks about a can. The dealer behind the counter says, "Sure thing, fill out this form for," and yes, we still have to collect whatever transfer fee applies in your state. Mike nods, fills out the form for, mails in his fingerprints, and waits somewhere between 6 and 12 months. Mike eventually gets his suppressor. That is legal. That is still how it works for Mike. Now picture Mike is buddy Dave. Dave is a $25 a year GOA member. Dave orders the exact same suppressor through Silencer Shop. The exact same week, Dave fills out a form 4473. Dave passes a NIC's check. Dave picks up his suppressor in a few days, not a few months. Both transactions are happening legally, in the same country, in the same week. That is how unusual the moment we are in really is. Your gun rights today depend on 3 very specific things: what organization you joined, what store you buy from, where you live. 3 variables. All of them matter. Now let us talk about the part the title of this video is referring to, the so-called counterattack and the data fallout. That has gun law Twitter absolutely melting down, because the headline truth is that the ATF did not appeal. Most gun owners took that as a sign that the agency had thrown in the towel. I do not think that is what is happening. I think the ATF is doing something more calculated, and if you do not see it, you are going to walk into a trap. Hey, real talk for 1 second here. About 70% of the people watching this video right now are not subscribed, even though they have been here for the most important part. Do not be in that 70%. Join the 50,000+ gun owners who get these updates the second they drop. Click subscribe and turn on notifications so you are the first to know, not the last. What we are seeing, based on reporting from outlets like The Hill and RAILA, Gun Owners of America, and several Second Amendment lawyers who have been posting threads all week, is a posture insiders are calling narrow compliance. The ATF is complying with the court order exactly, and only exactly, to the extent it is forced to. They are not extending the streamlined Form 4473 plus NIC's path to non-member buyers. They are not announcing refunds for people whose form for applications have been stuck in the queue for 9 months. They are not voluntarily opening up Form 1 trust applications. They are not issuing any kind of general guidance that treats the ruling as a nationwide policy change. They are following the letter of one ruling, scoped to a specific set of plaintiffs, and they are doing nothing more. That is strategic, that is deliberate, that is the counterattack. It is not with raids and it is not with seizures. It is with paperwork. It is with silence. It is with the slow, grinding bureaucratic strategy of doing exactly what one judge ordered and absolutely nothing beyond that. The ATF in essence is betting that the smaller the footprint of this ruling, the easier it is to overturn, narrow, or simply outlast as additional cases move through the appeals pipeline. Treat it like a siege, not a battle. They are not storming the castle. They are waiting for the castle to starve itself. So before I go further, I have to pause and put my lawyer hat on for a second. Quick legal note. This is educational information, not legal advice. I am a content creator. I am not your attorney. This entire area of law is changing literally by the day, sometimes by the hour. Always talk to a licensed attorney in your specific state before you buy, transfer, make, or modify any NFA-regulated item, even if the new rules look like they apply to you. An attorney will help you confirm that, document your status, and protect your rights if anything comes up later. Okay, hat off, back to the story. Now let me give you the 3 specific things from the last 72 hours that I think every single gun owner has to know before they make any move involving an NFA item. I want to walk through each one carefully. First, the form for Q, which is gigantic and totally unresolved. The ATF form for systems still contains hundreds of thousands of applications submitted before the August 13th ruling took effect. Many of those were submitted with a $200 payment that no longer has to be paid. Many were submitted by people who are not members of any of the 4 protected groups in the lawsuit. The ATF has, as of the day I am recording this, not made a public statement about refunds for those who already paid, has not committed to processing those applications on any specific timeline, has not said whether applicants outside the 4 protected groups will still have their form for approved under the old rules, or whether their applications will simply stall indefinitely. That is a giant pile of money, paperwork, and legal exposure, all of it sitting in limbo right now. If you filed a form for before August 13th and you are still waiting, I am sorry to say you are still waiting. Second, transfers across state lines, which is where I see a lot of regular gun owners about to make a serious mistake. Hypothetical example to make the point stick. Suppose you live in Georgia. You are a GOA member. You buy a suppressor through Silencer Shop under the new streamlined rule. You take it home, you shoot it, you love it. 6 months later, you get a new job in California. You pack up your household, including your guns, including that suppressor, and you move across the country. The federal injunction protects you as a Silencer Shop customer and as a GOA member. That is real. But that federal injunction does not magically make your suppressor legal in California, which has its own state-level ban. State law is still in play, always. A federal court win does not equal a get-out-of-jail-free card in any state that bans the item on its own. California, New York, New Jersey, Illinois, Hawaii, Massachusetts, and a handful of others still prohibit civilian possession of suppressors no matter what a federal judge in Texas has to say about the Constitution. Do not learn that lesson the hard way. If you have any doubt about your home state, talk to a local attorney before you buy or before you move with one. Third, and this is the sleeper issue that a lot of people are missing, what about every other dealer and manufacturer in the country who is not Silencer Shop and who is not a named plaintiff in the case? Silencer Shop is complying with the ruling because they are literally the lead plaintiff. The vast majority of gun shops in America, both your local storefront and the big online platforms, are still running on the old form for system. They are not covered by the injunction. If you walk into your local gun store tomorrow and say, "Give me a can under the new ruling," the dealer behind the counter will, in most cases, politely tell you no, fill out this form for and wait. They have every legal right to do that. They are not defying any court order. They are simply outside the scope of this particular one, until Congress changes the underlying law for everyone, or until a much broader nationwide ruling knocks down the entire registration scheme for every American. Most stores are going to keep doing exactly what they have been doing since 1934. These next 90 days could reshape your entire gun rights reality in ways we cannot fully predict yet. Subscribe now, because the next video is breaking down the real-life story of an actual buyer in Texas who took possession of an unregistered suppressor on day one, what paperwork he had to fill out, what his dealer said to him, and what 2 big surprises he ran into at the counter that almost cost him his purchase. Now here is the part of this whole story that is keeping most of the serious Second Amendment lawyers I follow up at night, and it is the part the cable news crowd almost never mentions. The fact that the Department of Justice did not appeal the Silencer Shop ruling does not by itself mean the federal government conceded anything important. The DOJ did not say the National Firearms Act is unconstitutional nationwide. The DOJ did not promise to stop enforcing the registration scheme against non-plaintiff gun owners. The DOJ did not promise to issue refunds to the people stuck in the form for Q. What the DOJ did was simply allow one specific injunction in one specific federal district to take effect against one specific set of plaintiffs for one narrow set of NFA items that tells you 2 important things. First, the DOJ is trying to keep the impact of this ruling as small and as controllable as possible. Second, the DOJ is very likely betting that either a higher appeals court will narrow or freeze the ruling when it is appealed to the next level, or that the next case in the pipeline will land in front of a judge who is more sympathetic to the old way of doing things. This is not over. We are not done. We are in the middle of the fight, not the end of it. The NFA has been under siege for the past several years, and August 2026 is not the final chapter. It is just the strangest chapter so far. Anything can still happen. A higher court can pause this ruling tomorrow. The numbers in Congress can shift. A new administration policy can change how aggressively the ATF enforces against non-members. All of it is still in motion. Do not let anyone, on either side of this debate, tell you the war is over. So what does all this mean for you right now? The real human being sitting on your couch watching this, possibly thinking about buying a suppressor in the next few weeks. Here is a 4-step framework to think through, not legal advice, just a smart way to organize your decision. Step 1. Check the date. As of the moment I am recording this video, the injunction is live. That status could change tomorrow. A higher court could pause it. Another judge could limit it further. An administration policy shift could change how the ATF reacts to non-plaintiffs. Snapshots in time matter here, so do not make a decision today based on what you heard me say last week. Step 2. Check your group. Are you a current member in good standing of GOA, SAF, FPC, or are you buying through Silencer Shop? If the answer is yes, the streamlined Form 4473 plus NIC's path may very well be available to you. If no, the old form for path is probably still the only legal reality you have. Step 3. Check your state. Several states have outright bans on civilian suppressor possession, and I already listed them. A federal district court ruling does not overrule your state, ever. Step 4. Check your timeline. If you do qualify for the new path, do not assume wait times will stay short forever. The moment this ruling went live, Silencer Shop's website traffic spiked, dealer phone lines flooded with calls, and even on. The new streamlined path wait times will almost certainly creep back up as more and more buyers pile into the system. The early advantage goes to people who move quickly and intelligently, not to people who wait 3 months and then rush. Let me wrap this up with the big takeaway, because if you remember nothing else from this entire video, I want you to remember these 3 things. Number 1, the $200 NFA tax is gone for suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons as of January 1, 2026. That one is settled. That is federal law no matter what any court does next. Number 2, the registration framework sitting on top of those tax-free NFA items, the fingerprinting, the photos, the form for process, the entire 9 yards, has now been declared unconstitutional in a serious federal case, but the ruling is currently scoped to a specific list of plaintiff organizations and Silencer Shop customers. It is not yet a nationwide policy. Number 3, the ATF is complying narrowly. The Department of Justice is staying strategically quiet. Gun rights organizations are already testing the limits of the new framework in real time, and a second wave of lawsuits is being filed as we speak. We are in the most dynamic, most unusual moment in American firearms law in an entire generation, and the next 90 days will very likely tell us whether we are heading toward nationwide deregulation of these items, or whether the old system slowly, quietly crawls back into place through aggressive administrative compliance and carefully chosen future cases. Nobody knows for sure. I certainly do not. Anyone who tells you they know for sure is selling you something. Here is the closing call, if you made it all the way to the end of this video. You care more about your rights and about genuinely understanding the legal landscape than 90% of gun owners in this country. That is not me hyping you up. That is just plain true. Hit that subscribe button right now. Turn on the notification bell. Share this video with at least one friend who owns a suppressor or who has been thinking about buying one, because if they walk into this uninformed, they could end up wasting 9 months of paperwork, or worse, accidentally breaking a federal rule they did not even know still existed. The window on this story is wide open right now. It is not going to stay open forever. I will see you in the next video. Until then, stay safe, stay legal, stay free, and stay informed.